Welcome, welcome, welcome in, everyone. Welcome to Care Concierge with Care Patrol, where education is the heart of everything we do. Care Patrol is a referral and placement and advocacy agency. We assist clients and families who are in need of finding care options. When those options include assisted living, independent living, memory care, or in home care slash sitters, we're paid by those providers for our services. So we always remain free to our clients. Like this education is free to you. And thank you for joining us here today. If you're new to Care Concierge and Care Patrol, we are accredited by the Alabama Board of Social Work, and we are renewing or attempting to renew our accreditation with the Alabama Board of Nursing, each of which tell us that today's class qualifies as 1.0 contact hour. And we are so glad you're here. If you wish to receive a certificate, merely being here is not enough. You must complete a password protected evaluation that's online. We'll give you the link here in a moment, and we give the password at the end today. So listen for that. I'll also post it in the chat room. We so much encourage discussion and questions. I know Pamela Strickland, our speaker, like all of our speakers, want this to be interactive so that it's a dialogue that provides you with the most benefit possible. If you have a question, please post it in the chat room and I'll interrupt Ms. Strickland and ask that of her at an appropriate time. If you're new to Zoom and you don't know where the chat room is, move your cursor to the top of your screen or the bottom. At one or the other, a black bar will pull up. On that bar is the word chat. Click that and join the conversation. We are continuing a little bit, in a way, our discussion that we had with Bill Nolan, an attorney, some weeks ago of elder fraud issues. But today that applies to a different sort of topic, maybe more specific in particular. Pamela Strickland of Medicaid Application Processing Services, or MAPS, who has, I don't know, I don't even want to say how many years, Ms. Strickland, many years of doing this sort of work, and has seen many, many, many different cases. Um, I've just posted the link. For those of you that are on the phone and are not able to see the chat room, or those of you who are on YouTube and not able to see the chat, the link for today's presentation is https colon // www.surveymonkey.com /lowercase r / all uppercase letters with numbers 6 Z as in zoo, Z as in zoo, Q 7 N as in Nancy 2. I've posted this again in the chat room. That is today's link. And without further ado, and with great encouragement for you to participate and discuss and ask questions, I'll introduce Ms. Strickland. Thank you so much for being here as always. I looked over the presentation and I'm excited to hear what you have to say today.
Thank you. It's great to be here and to speak. And today we're talking about an issue that I've had um, several cases that have come in over the past 6 months. So today, the first case that we'll be talking about for elder abuse is a female claimant, and she's 76 years old. Um, she was a widow with a history of dementia. Now, she has never been officially diagnosed with dementia. She has cognitive issues. But for this talk today, we're going to say she has a history of dementia because of some issues that she's had. This claimant owned a home. And she was a veteran. And this is important because not only did the family come to me for Medicaid reasons, but they had also gone to the VSO and applied for her to go into a VA home, which became very important during this process. The claimant receives as income her Social Security and VA benefits. She also has a small savings account, but she had no investment. She was not a wealthy lady by any stretch of the imagination, and her son lived with her. Now, her son is 49 years old and has never lived anywhere else. He's always lived at home. So, there was a power of attorney that she signed for him several years ago, which could be expected because he lived with her and he cared for her. So let's talk a moment about identifying the elder abuse issues that the family came to me with. Now, I met with the family, and they were quite concerned about some issues they had come across. This claimant had fallen and she was not able to go back home. So they put her in a nursing home. And during this time, they came to me and I explained to them to what we would need to file Medicaid. And so they started going into this process. And these are some of the issues that we came up with. The son had transferred her home into his name without permission, didn't tell anyone. The claimant had received an insurance payout for her roof. Now, some straight line winds had damaged her home. It wasn't just a roof, there were some wall issues. And so it was a hefty payout of $50,000. But once that was deposited into her account, the son transferred one half of that payout to his own account. And then several months later, he transferred the other half to his account. The son also transferred her automobile to his name. She didn't know anything about that. Um, the son and the had the mother paying all the utilities, and then he paid the mortgage payment. Now, the last two parts of this are not a problem. When someone lives in a home, whether they live with a child or a child lives with them, and the child owns the home, as this now is the case, they're expected to pay their way. So this claimant is truly able to pay her own expenses. She can pay the utilities without any issues whatsoever, as long as she's home. Once she goes into the nursing home, all that must stop, and she can no longer pay anything in the home. So when we started talking, um, with the family, we found out that the son had the claimant sign a deed over to himself, and he told her it was a step in getting the roof repaired. He said that it would make everything easier if it was in his name so he could sign everything and be kind of like the foreman over the work. And she said, okay. So, totally a lie. And then the son took the claimant to the bank to get his name placed on her accounts, telling her it was for her protection. Then the son changed all the passwords to the claimant's accounts so that he would be the one to have only the access to accessing them. So he pretty much took away all of her ability to even check her own bank account. And then the son filed a lost title to the car and had it placed in his name. So all of these things here not only are a red flag to Medicaid, but we could not get her approved for Medicaid because of these issues with the son. So on the house transfer, of course, the house was transferred illegally. So there are a couple of options. The house could transfer the son back to her, could transfer the house back to her, or the son could pay for the home and keep it in his name. So those are the two options. He could pay for it or transfer the house back to her. That would clear up that one issue. So that's how you what we call wash that. It goes back to the perfect standings, and it would not be a problem at all. And then at that point, if he were to purchase the home, it would have to be for fair market value. If he just transferred the home back to her, then she would have to sell it because she's in a nursing home. This we could do a caregiver affidavit for him because he's always lived with her, and he had taken care of her. But with the other problems we were having, that certainly would not be sufficient. So the illegal assets taken, the son will be required to repay these monies, or we talked about this with the family. The family could call DHR in, and if DHR came in, they would of course look through all of this, and then they would most probably take it to the court, or the family, and or they should do both, file a police report. So when I met with the family, we went through all of these. Then they had bank statements for me. I mean, I was able to look and see all of these transfers. We had evidence of this. We also had evidence. We had the deed that was signed over to him. We did not have the car title, and they could not get a copy of the car title because he would not supply that to them. So the family really did not want to take the DHR or the police report stance. They really wanted me to work with the son. At this point, I've not met with the son. I'd only been told that the son was quite belligerent and had no respect for women, which is great for me because I'm the one who's going to be talking with him. So I really had to frame my conference with him in a way that did not make him feel unsafe. He needed to be able to share with me his side of the story. So I had a conference with the son, and he he opened up a little bit about things he had done for his mom. I asked him if he could, give me receipts for those items of transfer of the monies. What did he spend that on? He built a porch on the front of the house for her to be able to get her wheelchair up. And I said, that's great. We can certainly turn that in as part of your care for her. And I know it came from her funds, and that's perfectly fine. And he said he had those receipts, and I said, well, that's great. That's $12,000 we can use. So of course we had this other $38,000 we had to account for. And once I kind of approached that subject with him, he stood up and said that he was not going to be made the bad guy and he was going to leave. So I calmed him down and I had him sit back down and I told him I was not here to blame anyone. I just needed facts. I understand you built the porch, and I understand there was an air conditioning system he had put in for $13,000. His mother had paid 10 of that and he had paid 3. And I said, well, that won't do since the home is in your name. She can pay one half of that, which would be, the 6,500, and you have to pay the other 6,500. He was not willing to do that. Then we talked about the money that he had. Now he had transferred the $25,000 and he had placed it into a special account for her because she was not wise with her money. A lot of her money went to QVC, as we see a lot when I talk with these people, and a lot to Amazon. So he was trying to hold some of her money. He actually gave that $25,000 back, and we were able to place that into the Alabama Family Trust for her. But so he had that back, but he was not willing to even talk about any of the other money. He would not give us any of the other money back, nor would he furnish any receipts that went with those monies that he had taken. So after I met with him and he left, I talked with the family and I explained to them that the $25,000 that he had given back was all the money that he was going to give back. There was no more he was willing to do. He was not willing for us to um, deed the house back. He was not willing to give the car back. He was not willing to do anything we suggested to him or what Medicaid required. Out of the blue, thank goodness, they got a call from the Huntsville VA home. They had one bed left for a woman. So instead of a 2-year wait, which is what they were told, they were able to move her in the veterans home in Huntsville, Alabama, within 3 days after they were notified that she had a bed available. So we discontinued all Medicaid filing. So what this simply means is all of these things happened. but the family did not want to pursue a police action and they did not want to pursue DHR action. So they were very smart. They had the claimant sign a new power of attorney, and the family happens to be a brother and a sister to this claimant. So she gave power of attorney to the brother and the sister, and then they went to the bank and they closed out all the accounts, all the joint accounts, and they moved everything into an account with just her name with them as powers of attorneys. So he no longer has access to any of her monies now. Um, Income was still going into a specific account that had both of their names on, but we talked with the bank and they took his name off that account. And that account was closed probably a week after she got the VA home and moved to a new account at Wells Fargo, which was the POA account. So everything was taken from his hands except for he still has the house, he still has the car, and it's up to the family about how they want to pursue that. But right now, everything is calm. It's all copacetic with the VA home. That's where they plan to keep her. And so VA, it was the answer for her. And Medicaid was discontinued. This was a hard case in that the family really wanted to get this rectified, but the son was not willing to meet them halfway. He was not willing to do anything. Um, so it was going to be a court case in the end and was probably going to split the family.
I have a question. What would
Huh.
have been the fully what for him to pay back what he had taken? What would that number have been? And would they have been on the hook to pay that to this nursing home had he not?
Yes, the home was worth $225,000. So there was a transfer penalty, if you will, with Medicaid for $225,000. So that is years of penalty that they would have to private pay the nursing home. Not mentioning the car. The car was a $24,000 car. So you add that to the penalty. So you're talking upwards of $250,000 that the penalty would have been, and they would have been on the hook for paying the nursing home private pay at $10,000 a month until that was paid in full. So that would have been, and when I say 10,000 a month, that was just room and board. That wasn't all the extras, and so it could have been up to 12,000 a month. So if they had gone to court over this, the home probably would have been sold and the money's placed into a conservator account for her and used for her care. And the same with the car. And the conservator would probably been the power of attorney, the brother and the sister who'd have been over that. And they could have used that money for her care, of course, at that point, and it would have been copacetic with Medicaid because the home was sold and the money had come back to her. So that's how that could have been rectified if the court had been involved. So our case number two of elder abuse is an 87-year-old male, and he had a history of strokes. And so this gentleman was fully cognizant when he called me. He just was unable to do daily activities. He couldn't get up out of his wheelchair without help. He needed help getting to the shower and things of that nature. So at 87 and a history of stroke, you can imagine that he needed some help. So, but he was totally mentally competent. The claimant owns a home. The claimant owns two classic automobiles. When I say classic automobiles, one was a Corvette, one of the first ever produced, and the other was a Model T that had passed down from his uncle to him. Then he drove he had a 2024 Jeep. Um, and then the claimant had assets, including CDs, annuities, investment accounts, land, and an IRA. So this claimant was well off. He could have paid for a nursing home for quite some time, but he needed help in the home. And so claimant had his daughter move in with him in 2025. So there's no caregiver exception for that because she didn't live there for 3 years. And the claimant had no power of attorney. That's something that he just never got around to. So there was no one really to take over for him. The claimant's assets were in his name only, as he was a widow. His spouse died 25 years ago. He never remarried. So the claimant had three children, and only the daughter lived in Birmingham, but two sons lived in Texas. So the daughter moved in with him, and this is where it got very interesting. When he called me, he said she had actually gone out to get groceries when he called me, and he said he was referred to me by an attorney. He said he couldn't access his bank accounts anymore. He didn't understand that. And he just felt like something was wrong. And he felt like maybe he needed to go into a nursing home or into a community that he could get care there and he could take care of himself as far as his assets and all. So I said, well, let's talk about what you're seeing. And he began saying, well, I can't see anything. That's my problem. I don't know, but he said, I got a bank statement in, and he said, I didn't buy these things, and that's not my signature. I said, okay. All right. I said, you don't have a power of attorney, so I need you to call the bank, and I need to get me on a call with you, so I can hear. And let's talk to him about what's in your accounts and what's been done. So he did that. And we were told that there were many checks that had come through that he did not know about. He had two CDs that had matured and they had not been redeposited. They had been cashed out, and he did not know about those. And the daughter had taken that money from his account. Then they found out that the passwords were changed. He had them changed on the phone that day back to where he could access his accounts. And he said that um, his daughter was no longer to be able to do anything like that. And they said, well, you had mobile banking. So she was able to change that. So we got this information and we found out that she had transferred money from savings into her account. And so we had to confront her, but we had to do it in a way that, well, we just had to do it in a way that didn't make her feel as if we were going to put her in jail, basically. So he said, well, I can come in. I can certainly come in. I can have her drive me there and we can talk. So I really had to think about how I was going to approach this. So we had a conference and I didn't mention anything that we had found out, but this is what I told her. I said, okay, as I was speaking with him, I said, okay, we're going to go Medicaid route. This is what Medicaid's going to require. They're going to require all savings accounts records for 60 months, all investment account records, all CD statements, proof of all care expenses, copies of all hospital charges and payment receipts, copies of all prescription invoices with payment receipts, and proof of all monies moved from the claimant's accounts with receipts. I was then asked, well, what do you mean money moved from his account? She asked me this, and I said, well, any money that's been paid from his account, we have to have receipts for. And you could just see this look on her face as if she had been caught. She knew at that point that she was in trouble. So um, we after we spoke and I told her what we needed, they left. And then I contacted her 2 days later by her cell phone, and she said she just was not willing to get the bank statements, nor was she not willing to gather information for the CDs. It was just took too much time, and she just didn't have the time. She was too busy. And I said, well, I'm sorry, but we have to have this one way or another. And I was trying to get through to her that there were other avenues we could take if she did not um, do what we needed her to do. And she just was not willing to gather even the payment details. I told her then that we would need to have take other steps and that I would be talking with her father, who is fully cognizant, and we would decide what we were going to do from then. Well, I immediately hung up, and the father called me. I had texted him. He called me, and I said, I need your son's number in Texas. So he gave me his son's number in Texas. He had two sons, but he gave me the older one. So I called him, and I explained to him what we were going through, and he was furious. He had no idea. He said, I've always thought my sister trustworthy. And I said, well, this is what's going on. So he said, I'm going to step in immediately. So I gave him the name of an attorney who dealt with these issues. And so the son took over immediately. And he is filing for conservatorship and guardianship over the father. And the father said, yes, please do. And I asked him, I said, well, why didn't you just do a power of attorney to him? And he said, well, he wanted to do a conservatorship and guardianship because he wanted the court to see everything she had done so that if the court wanted to take any action, it would be out of his hands. I thought, that's a great, okay, I totally get that. So that's what they did. So the daughter will be restricted from access to all of his resources. The daughter must evacuate his house immediately or face criminal charges. And the father replaced in a nursing home on private pay until the court hearing is held and a conservatorship guardianship is granted. And all assets stay in place until a court decision is made. Now, this means that they're going to place him into a nursing home and they're going to private pay for him until this issue is resolved. It's right now in the courts right now. But from what I understand, his assets totaled the gentleman's asset, the claimant's assets totaled a little over $1.8 billion. She had funneled about $300,000 to her. So in the state of Alabama, that's at least 10 years in prison if they go that route. I doubt the family would go that route. I think they're just going to ask that she be barred from any kind of well, as a conservatorship will say, the son is the conservator, and the backup conservator would be the other son, who is the younger son, who is a tax attorney. So that would be the backup. So you've got two sons who would handle this now, and she would simply be out on her own. So that's how that case ended. We don't have, we will file for Medicaid once this is finished, and we have someone appointed over him. And all of these assets, the gentleman will sell his home because he can't get around anymore, and we will place his assets into the Alabama Family Trust for him. And he was totally okay with that. He wanted that. And he knows that his son will be paying for things for him. And he said, look, at my age, I could have another stroke tomorrow and I could be incapacitated. He wants this taken care of as soon as possible. So they felt conservatorship guardianship was the proper way for them so that the court could see what had happened. So that's why that went that way. And the power of attorney was not appointed. Any questions on that?
I'm just astonished at the amount of money.
Oh, that is yes. I've had up to $1 million transferred to a child before when Medicaid caught it and called me. So it happens, and they were very shocked it happened with her. They just had no idea. And the research showed that she was not someone who needed money. She just felt entitled.
Hmm.
So that's how that happened. So our third case here, this one's totally different from the other two cases. This is a 74-year-old male claimant with a spouse, and the abuse was toward the spouse. So we'll talk about that. The history of this claimant, 74-year-old male, and he was
I'm
diagnosed
sorry.
with,
I have a question on the
oh,
last one I
sure.
missed, Mr.
Yeah.
Strickland. Miss Rafalski said, wouldn't it be faster to assign the son POA?
Oh, it would be much faster. It would have been like a day, but they wanted to go the court route. And I understood that because what's going to happen to these funds that were taken? Medicaid is going to consider that an illegal transfer. So you have to go to court so that that will not be an illegal transfer. They have to know and they have to do something about it. That's one of the reasons why they went to the court because she couldn't transfer that money back. Although I think she could give back probably three-quarters of it. So you're talking maybe, $50,000 of a penalty there. And the family's not even going to accept that. They want all the money back. So that's why they went the court route.
Wow.
Yeah. But you're right. POA would have taken care of it in a matter of a day. They sign it and get it notarized, and they're the POA. So it's just a decision of the family. We have to honor that. So this claimant, he has frontal lobe dementia. Now, if any of you ever know anyone with frontal lobe dementia, you know they can be quite combative, and he was very combative. He was not this way his whole life, mind you. He was a very kind and caring man. He was a professional football player in his younger days. He played pro ball. He played Canadian football. So he went to University of Alabama, played under Bear. So this is not something that he grew up doing. The frontal lobe dementia made him this way. So he also suffered from paranoia and he distrusted his wife because of the frontal lobe dementia. So the wife had absolutely no access to any of the funds. He paid everything. So she had her own little bank accounts, but the majority of the money and all was in his name. The claimant would never appoint a POA because he distrusted everyone. So there's that issue there. The claimant hid all the money from the spouse. And when he started getting, before the family realized how bad he was, he would get combative here and there, and they just thought that was part of dementia. But before the paranoia and all really became all that obvious, he started hiding money, which means he took it out of their account and he would put it in other accounts without her name on it. And she had no idea he did this. And so these things had to be found out. So, um, so he couldn't have a POA assigned because of the diagnosis. So the elder law attorney did file for a conservatorship guardianship for him. And it took a while for that to come about because we didn't know what all he had. Um, so we know that conservatorship means that a conservator is appointed over his finances. So we had by to go to a bank, we had to do everything we could to see what he had, but no one had any authority to do this. So even they didn't even have a conservatorship yet. So the son is a banker and he works at PNC Bank and he was able to pull records from there from the joint accounts and he was able to follow. He had just simply transferred the money to these new accounts. He had not written a check. So he was able to follow the transfers and find out where all of this money was transferred and what was done with it. So that was great. That helped a lot. When the conservator was appointed, they knew where to go to get the financial statements that was needed for the conservator to be able to say how much is the bond, and they had to appoint the bond. After the conservator found out what was in the accounts, the conservatorship order listed the son as the conservator, and then the conservator filed a bond for the assets held by the claimant. And so this bond ended up being several $100,000. So they found that money for the spouse. Now, we had to also get a guardianship over his body because we had to be able to make sure that he was placed in a nursing home. Well, conservatorship's over the finances, so now a guardianship is over the body. So we had him placed into a nursing home, and it was against his will, but we had to because the court was getting involved. So this guardian can make all the decisions for him health related. So went to the nursing home and explained the process to them and explained that they'd be private paying during the conservatorship process. So the guardian will make all those decisions related to the life decisions for this claimant. So that's how that got set up eventually. Now, I had to come about and get a snapshot gathered for the information. And the sad thing was is that the spouse really couldn't help me. She had no idea what they had. She had never written a check from the joint account. He did everything. In his later years, he'd become an accountant, so he did everything. So she had nothing. She had no idea what to do. So once we got copies of the conservatorship and guardianship issue settled, we were given the information from we were able to get that to the bank, and the bank was able to print out everything we needed regarding all the investments that he had that were different than the bank accounts. So we then were able to put that on the snapshot sheet, and that is simply a sheet which lists all of their assets at the time he went into the facility or was institutionalized. And then I back out of that all of the payments for his care, which is part of what he could be paid for him. And then once we added everything up, we split the finances. We added everything up, and then we put his portion into the Alabama Family Trust, which was around $200,000 for him, and she got to keep 157,000 of the finances. So that's how she got to keep that money. Now, he is still very combative. So when we told him that we were getting financial data and all, he was not happy with that. Um, they tried several different medicines with him, and there were a couple that calmed him down a bit. So when she went to visit him in the next, I'd say the next month, he was actually able to sit down and talk with her, and it was done. He was quite pleasant. So we had thought about sending him to the Mary Harper Center to see if they could get his combativeness under control, but the doctor there was able to do that with some medicines. So the house that was owned by them was quit claim to her as per the court order. The court gave her the house. Now, the house is quite large, very large house, too big for her. So when the house sells, that money will go to her, but a portion of that money will also go to him. And the reason for that, even though it was quitclaim to her, he still has a right to that house under the conservatorship. He has a right. I think they apportioned that right at 45% for him. I don't know how they figured that, but they did. So he'll get 45% of the sales price of that house. So when that house did sell, and it sold for a little over $350,000, 45% of that went to the Alabama Family Trust. And then we paid Medicaid for a couple of months of Medicaid care to pay them back for that, which is what is required. It was a line item on the closing statement. So basically, his Medicaid balance started over at that point because we had paid them back for the couple of months that he was there. So she now lives in an apartment that is, well, no, it's not an apartment. It's a townhome that the son bought for her, and she lives there. And so we had to also, he had caregiving expenses. They had caregivers come in the home because she just could not handle him on her own. So we presented those caregiver expenses, and Medicaid approved all of those, which means that those could be also attributed toward his care, which meant we placed less into the AFT on his behalf. So the son was appointed as the conservator and as the guardian of the claimant. Now, after Medicaid calculated finances for the couple, after everything was split up, no further spend down was needed. She had the part that she could keep, and we put everything else in the Alabama Family Trust. But her income was only Social Security at 900 and something dollars per month. Well, we know that the NIMNA for 2025 was over $1,500, 1,573, I think it was. And so they were able to give her a spousal allowance to get her up to, I'm sorry, let me look at this. No, 2643, and they gave her 1,500 and some odd dollars for her Memna. So she is now at the community spouse amount, and that's going to go up, of course, in July. But the abusive part of this, why this case was so different, was even though there was abuse to her. I mean, she was hit and pushed and things of that nature, and the funds were hidden from her. It was not done out of meanness. It was done out of frontal lobe dementia. And so that's a totally different case. It's not something that you get anyone else involved in. It's something that you work through with the meds and with proper care. And that's what this gentleman got. So as of this point, as of yesterday when I called, he's able to now leave the nursing home and go with her to eat. He's calm, and so it's helped a lot. He does get angry with the care and does not always agree with what they want him to do. He gets a little combative there, but it's nothing verbal. It's not verbal like it was, and it's not as abusive as it was. So this poor gentleman, some have asked, and I asked the family this, do you think it was from being concussed in football? And they said they did not know that, but they were just told it was frontal lobe dementia. So that was my third case. Any questions on this one?
We do have Barbara
Okay.
Powell ask, wouldn't if she used the money from the sale of the house for another home, the spouse, I'm sorry, the spouse wouldn't get a portion and it wouldn't be a transfer since Medicaid doesn't count the house if a spouse lives there. Am I correct on this?
You're right. They can certainly buy another house and live there, and it's their house. I mean, absolutely. But the problem is that um, this woman is in great health and will live a lot more years, and she needed money to last a long time. So they felt like the portion of her money needed for her care, and so the son bought a townhome and just paid for it, and she's living there and just using that money to live on for as many years as this money will last. So that's why they did that. But you're right. If she were to turn around and bought a smaller home and put that money into it, absolutely, that would have been her home. It would not have been any kind of transfer penalty with Medicaid. This was a family decision made by the son and the daughter-in-law. The daughter-in-law is a doctor, the son is a banker. And this is just they just felt like they could buy the home and move her into it and use this if she ever needed care, they would have money to use for her care. So that they're thinking of the long run for her.
Okay. And I have a couple of questions, kind of
Mhm.
basic. One, and you may have said this already and I didn't catch it, but quit claim, what does that mean?
That means that the court uh, basically took his name off the house and put her name on the house. It's called a quitclaim deed. It can be done between spouses, and Medicaid does not say that that's a transfer penalty. So they just basically took his name off the deed and put it in her name. But they did give him a portion of those assets when the house sold.
Okay. And then you were using I think an acronym that I didn't catch. MEMNA.
Monthly minimum needs allowance. That's what they call the spousal allotment. She cannot fall below that amount. 2643 for 2025, 26 until July. It changes in July. And so they would take a portion of his income and give it to her to get her up to that amount. Honestly, that amount of 26 is what they call the right above poverty level. So she has to be at that. And so they give her a portion of his income to get her up to that, to get her above poverty level.
That's 26 what?
2643.75.
It's always so hard to remember. 26
I have to try and look at it
43
every time it's on my board, on my whiteboard when I meet with clients, and it'll go up in July.
Okay, July.
They change that in July, and then we do all new calculations in July for all of our clients who get them in, who get the spousal allotment.
I
Now, that's
think
not
that's,
saying, I'm sorry, go ahead.
go ahead. I'm sorry.
I'm just saying that's not saying she can ever have other income. I have some clients who invest in an annuity that gives them a monthly income stream, and they could certainly do that, and she can have that monthly income stream, but it just lowers the amount of the amount she'll get from her husband. She can have income of $6,000 a month, and she wouldn't get anything from her husband. But that's her income, and they can do with, they don't take her income. So I have advised some spouses who have a lower income, and that's still not enough, but they have their portion of the claimant's amount that she can keep. I tell them they can invest in an income producing annuity and that would pay her an income each month. And so she wouldn't have to worry about going into her savings. Once she puts that money into the income producing annuity, she'd get an income for the rest of her life, and that would get her even up more. So those are the types of things you can do to get the spouse to have more income.
Okay. And I'm curious, when you refer attorneys, are these attorneys you've worked with in the past? I mean, I know
Mhm.
they are, but did you
Yeah.
work in the same office?
I've worked with several, and my main go-to is Bill Nolan. I was his par he and Ben were partners, Ben Stewart, and I was their paralegal for 10 years. And so that's all I did was Medicaid and VA for them. And so when they split and Ben went another route, he went into the investment community and I opened my own business. And so Bill continues to send me all Medicaid, and I send him those things that need an elder law attorney because he's so good at it.
Right. Yeah, he's
And
one of our frequent speakers.
yeah, yeah. And so I send him those, and he takes care of my clients, and I'm very thankful for it.
And you mentioned, I just have a question. The VA, is that just no longer accessible because of the look back? I mean, have those applications sort of stalled?
No, VA, I don't do VA anymore because of the white paper. Once it became a 3-year look back, and once it became so difficult to obtain, it's worse than Medicaid. So I advise all of my clients, if they are VA, to go to the VSO office in their county. Most people go to Shelby County, St. Clair County, something like that, and get them to fill out the forms for them. I've had clients approved for VA while I'm doing the Medicaid application. It's just that it's just different. We have some that are DSE clients that have a 40 or 50% rating. And then we have some that are aid in attendance. That's what I deal with the most. They need the aid in attendance of someone every day for ADLs. This is usually for the home when they're in a home, but when they go to a nursing home, that aid in attendance, they can still apply for it in a nursing home and they'll still be awarded that. The difference is if you're at home, you're going to get the full amount of aid in attendance, which is anywhere from $1,500 to $1,800 a month for, just depending upon who the person is and their financial situation or what they're paying. But when they move into a nursing home, that changes. Medicaid's going to be paying for that. So the VA reduces to $90 per month, and that's pocket money. They get to put that in their pocket, which means they don't have to pay that to the nursing home. They get the 90 from VA and the 30 from Social Security. They keep $120 per month for whatever they need. No receipts are needed. A lot of people use that for buying their loved ones books or snacks, whatever they want, get their haircut, whatever. They use it for that. And so I tell people, look, if you're a veteran and you want to get these benefits, it only helps you in a nursing home. So at first, it will continue in a nursing home until we show them the approval. And then at the point they get the approval, they then reduce it down to $90, which the individual, the claimant gets to keep and can use for his care however he wants to use it.
So Medicaid only allows $30 to personally.
Social Security allows 30, but if they have VA, there's 90 and 30, 120.
Got it.
Yeah. And that's a great help to some families.
Well, we're losing that generation of wartime vets. I mean, Korea's pretty much aged out. Now we're into Vietnam.
Yeah. Yeah, and that's true. We've got some that are coming in now from Desert Storm who have or mentally incapacitated by a sh things like, well, disabled, like a shot to the head, things of that nature. And so we have those, and they of course get DIC. They definitely are rated for that. But then they need aid and attendance at home, and so there's a choice to be made. Which one do you want? Well, depends on where you're rated for your disability. Sometimes aid and attendance is higher, but disability, you just don't know. You have to look at both options.
Lee Duncan has a question. She says, when you say Social Security, do you mean SSI for keeping the $30 a month?
SSA, SSI is the disability payment. You still get to keep it. If you have Social Security, you get to keep $30 a month, whether it's SSI, SSA,
Okay.
SSDI, or SSA. Yes.
All right.
Yeah. And if you're not a veteran, that's all you get to keep is the $30 per month. Of course, you have to remember the claimant can have up to $2,000 in their bank account, not a penny more. So when we talk with families, we say don't let it be $2,000. Keep them at about 1,500. Because if you go $2,000 and a penny on the first day of the month, they're going to kick you off Medicaid for that penny for the month, and you have to private pay for that month. So it's extremely important that people understand that they get to keep money in their account. But I tell them keep it around 1,500 so you're not even worried about going over that $2,000 on the first day of every month for the life of that client on Medicaid.
Right. Mm. All this is just so involved, and someone commented that it all seems so unfair, but she supposes it's legal.
It is unfair, and that's why and I'll be honest with you, that is why preparing 5 years out is so important. And I'll tell my friends this, I've told so many people at church this, and that is that you need to have a 5 year plan, which means you need to go to an elder law attorney as soon as possible to have a 5 year plan done so that if you were to have to go into a nursing home and you had your 5 year plan done 12 years ago, you have nothing to worry about. Because in that 5 year plan, they're going to put the house in the name you want it placed in. They're going to set up trust for you in a way that saves your nest egg, things of this nature. And as long as it's done, you know, before the 5 year look back, things are safe. But the sad part, and I have gone through this so many times with families, you get an elderly couple who've worked their whole life. Classic example. I had a farm family. These people were cotton farmers and they had corn. And they had farmed this land for, I don't know, over 100 years. It was grandfather, father, now to the children. And the father they had set up a nest egg. They were very nicely set up. They wanted to save it for their children. They had to land there and everything. The mother passed away, and so it fell to the father. And no one even thought, I mean, he was healthy. He worked the land. He just had a stroke one day. Doctor said he couldn't go home. He had to go into a nursing home. So here they had 250 acres of land. They had a nest egg that was well over $300,000. Farm equipment like you would not believe. I mean, millions of dollars of farm equipment. And he had two sons and two daughters. And all of that, we had to do some planning because all of that was going to have to be sold or purchased by the family. So it was a very difficult conversation. But it turned out to where the two daughters and the two sons bought the land, and that was well over $1 million of land because it was producing land. It was a production type land. Bought the farm, And then they were able to keep the rental, the farm equipment was a rental lease agreement with John Deere. So they just renegotiated those and they kept those. The nest egg had to go into the Alabama Family Trust, so there was no money. They started from scratch as children in that farm. But at least they had the farm, the materials, and the land. But they didn't have that nest egg. So I see it, I think it's quite unfair, but rules are rules and we just have to follow them. And they bought the farm and everything for fair market value. So it was quite expensive.
Amy Garner is asking if you know who to contact in Mississippi for Medicaid.
Mississippi, yeah, I've done Medicaid applications for Mississippi and they're totally different than Alabama. And in Mississippi, the Mississippi Medicaid they do everything on their own, and it's different. So I don't have any. Well, let's put it this way: I have an attorney in Mississippi. I can't think of his name at the moment, but I can most certainly get that to you. But he sends his clients to me, even in Mississippi, and so I can find if someone needs an estate, elder law attorney in Mississippi, I can certainly find one for you.
We'll copy. So, in order to complete the evaluation, you'll need the password for today. And when I send out the certificates, I'll copy Miss Strickland on it. So, if you have questions for her, you'll have her ability to contact her. And I'll also attach her slides, Miss Dawson. The link today again is https colon // www.surveymonkey.com /lowercase r / all uppercase letters and numbers 6 Z as in zebra, Z as in zebra, Q 7, N as in Nancy 2. That is the link for today. And the password is qualify. That's capital Q, lowercase UALIFY. Qualify is the password. Thank you all for being here. Thank you as always, Ms. Strickland. It was fascinating. I'm
Thank
sure
you.
you'll be hearing from some of the folks on this, and I hope you hear from some of the folks on here. We appreciate you being with us as always. Lots of thanks coming in the chat room. I hope y'all have a great couple of weeks. Join us in 2 weeks, and we'll have another contact hour. Remember, we've moved our contact hours to Tuesdays this year, and we'll see you in a couple of weeks. Y'all have a great one, and hopefully the weather's going to participate with us. Thank you so much.
Bye bye.
Bye.